All right, everyone. First and foremost, I just want to note this session is being recorded. So please note that if you do not want to be shown on video, just turn off your cameras. And my name is Tess Dudek. I am a staff attorney at Connecticut Fair Housing Center and a member of the FHCR Planning Committee. And I am delighted and proud to introduce my colleagues from Connecticut Fair Housing Center, Rashida Rattray, who's our Education Outreach Coordinator, Maria Cuerda, who is our fair housing advocate, and Pam Heller, who's a staff attorney at the center. With that, I'll turn it over to Rashida to get us started, and looking forward to this presentation.
Good morning, everyone. Getting my slideshow set up. I hope everyone is doing well today. And I'm really excited for this presentation. So we are going to be talking today a little bit about fair housing enforcement in a time of crisis. We have had an ongoing housing crisis, not just in Connecticut, but nationwide. And we're happy to give you the Connecticut perspective on some of the issues that we've been dealing with here in our state, and hopefully able to have a hearty discussion with regards to, what you may be seeing in your state or any takeaways that you may have from this presentation that'll be able to help you in the work that you're doing. I'm going to give a little bit of background on our agency and kind of the work that we do here in Connecticut. Our mission is to ensure that all people have equal access to housing opportunities that are ideally free from discrimination. We recognize that there is an intersectionality to all the work that we do, and we oftentimes focus on the intersection of poverty and housing discrimination. We also assist Connecticut homeowners who have been hit hardest by the nation's ongoing foreclosure crisis. So if I were to separate the work that we do into some tidy categories, we offer foreclosure prevention and intervention services to Connecticut homeowners who are going through the foreclosure process or are at risk of facing foreclosure. They're able to talk to legal staff to get some direction, to get some help with regards to that process. A lot of the times, our residents will lean on their local community organizations to get help through the foreclosure process. But unfortunately, those agencies can only go so far, right? The foreclosure process can get a bit litigious. And this is kind of where we step in to kind of bridge that gap and help people to get answers to those more legal questions that they may have. Our education and outreach initiative is spearheaded by me. I am on a mad dash across the state of Connecticut to ensure that people know that we exist as an agency where they can report housing discrimination if it happens, and more so to be educated on their rights under the Fair Housing Act. Our policy advocacy section is really geared towards ensuring that current equitable policy, the fair housing policies that we have currently stay in place, and to be able to advocate for more equitable policy where we see fit. Our tenant organizing and movement lawyering piece is one of our newest sections of work, and it is one that I am the most excited about. Oftentimes, tenants can be in these positions or in these situations that often make them feel a little disempowered. But in getting into these neighborhoods and these communities, in talking to these tenants and letting them know that they do have the right to organize, and by really lawyering in those communities, we're able to help people to be uplifted and to understand where to find resources and how to utilize them best. Lastly, we are a fair housing enforcement and investigation agency, meaning that we do have the right to investigate fair housing discrimination claims if they're brought to us, and then, take whatever necessary action if discrimination is found to enforce the Fair Housing Act. Now, that could look different in a plethora of different ways, right? It could be as simple as, maybe writing a cease or desist letter, and it could be as complex as representing someone in a case, right? In this presentation, we hope to kind of give you some insight to some ways that we have utilized enforcement to, continue the work of the Fair Housing Act. So we do have a plethora of protected classes in Connecticut, and I'm always so proud when we get to this slide. We do have our federal protected classes, which we all know are race, color, national origin, sex, disability, religion, and familial status. But Connecticut has really taken the initiative to add a lot of other protected classes to our state-specific lists. So we have ancestry, marital status, age, sexual orientation, lawful source of income, gender identity and expression, veteran status, and most recently, victims or survivors of domestic violence has been added to this protected classes list. What we always advocate for is for people to, get in touch with us and learn about what that discrimination looks like, so that they're able to report it, right? Because this isn't a definitive list. It can look different within the next 2 years, the next 5 years. Be empowered to understand the Housing Act and thus report when it happens. So I gave Connecticut on the back did classes, but now I kind of back have amazing. We still unsegregated state. 7% of our population of color living in 8% of Connecticut's towns. And we often notice that people with disabilities and people who have housing vouchers experience discrimination at higher rates than every other protected class. And what that looks like on a map is this, where the percent of non-white residents by census tract is indicated by the green on our map, or the teal rather, on our map. So we're doing a very good job at knowing that we have fair housing protections in place, but we're really trying to make sure that the Fair Housing Act is enforced and realized across our state, so that we can crack down on being so segregated as a state. So today I want to introduce you again to our panel. We have Pamela Heller, who is a staff attorney here at the Connecticut Fair Housing Center, and she's been practicing here since 2011. Her caseload includes her fair housing enforcement and other tenants' rights issues. So Pam, thank you so much for joining us today. And also we have Maria Cuerda. Maria has been doing work with tenants and tenant unions to address issues around poor conditions and rising rents. So we're going to kick it over to Pam, where Pam is going to give us a little bit more detail on our intakes that we have been seeing here at the center.
Thanks so much, Rashida. I'm happy to be here. The title of our presentation today is, Fair Housing Enforcement in a Time of Crisis. And so I think that one of the ways to illustrate the situation that we're dealing with in Connecticut is by looking at our intakes. We get calls from people all over the state. We take calls from anyone, and we at least record what they're calling us about. And so I took a look at those and I put together some statistics that I thought would demonstrate, the situation we're facing. And then I'm going to talk a little bit more about how that impacts my work and the other types of trends that I'm seeing in the day-to-day intake work. So if we can go to the next slide, I don't think I have control. So thanks. Great. So this slide is a demonstration of our intakes, the yellow being, fair housing issues. And that could mean somebody asking for reasonable accommodation. It could be, a complaint related to, source of income discrimination, any other type of protected class, right? So these are very broad. It doesn't, these numbers don't mean that we verified discrimination in all of these cases, but that was the question or issue in the call. So you can see that, from 2015 to 2019, we had, a very low number of landlord-tenant calls. And we had, particularly, most of our calls were categorized as fair housing. it's possible that some of these were miscategorized and we weren't as conscious of it at the time. But nonetheless, you can see that in 2020, the number of intakes annually increased significantly. And the primary increase was in those that we would categorize as landlord-tenant. So, you know, we can see that, you know, there was a clear trend, and this is partly the crisis we're referring to, is, you know, the eviction landlord-tenant crisis. However, you know, there's also an issue of affordable housing that we know predates the pandemic, and that's also the sort of context that we're operating in. And if we can go to the next slide, just to demonstrate this another way, our average number of intakes has significantly increased since 2020. So the annual average was 625 between 2015 and 2019. And then the annual average has been over 1,100 in 2020 and on. This does not include 2023 yet, but I have not seen intakes slow down. So that just kind of gives you some context of, you know, that we're operating in. And so I want to talk a little bit more about what the issues are that we're seeing. And I am guessing that these are not unique to Connecticut and not unique to our agency. But I want to, you know, share with you, and hopefully, you know, welcome questions, you know, and other input to hear from you as to whether, you know, you're seeing similar things and how your agencies might be handling this type of increase in numbers of people seeking help. So one of the primary issues, and let me also say that, you know, our work unfortunately does not include a lot of representation in summary process or eviction cases. What we do instead is provide people with advice and referrals in those cases for the most part. But there is an intersection that we operate, you know, between landlord-tenant issues and fair housing issues. And that's what I'm going to focus on, is how our work, you know, has been able to evolve to incorporate these issues and address them from a fair housing perspective. So one of the you know, one of the slides that you saw previously addressed segregation in Connecticut, and you saw that there are some centers of segregation that are in our cities: Hartford, Bridgeport, New Haven, Waterbury being a few of those. And the reason I want to mention this now is because when you look at eviction statistics in Connecticut, they're also centered in those areas. So those 4 cities I mentioned, and actually, Rashida, if you don't mind going back to that slide, just so we can take a look at it while I talk. Okay, thank you so much. So the 4 cities I mentioned are Hartford, Waterbury, New Haven, and Bridgeport. And those cities account for 14% of our population in the state. However, they account for 40% of our eviction cases. So when you overlay that with segregation, you can also see that there is a significant discrepancy between, you know, people being evicted based on race. And so that is one of the reasons that, you know, we began to address eviction and take these intakes and try to give people as much advice and information as we can to get them, you know, to guide them on that path. There is a clear intersection between segregation, discrimination, and eviction in our state. So, and then another way that eviction and the Fair Housing Act overlap is in disability. And, you know, people who have disabilities, I don't have the statistics on this, but based on, you know, our intakes, I would say that it's a significant portion of people who are facing eviction also have disabilities. And there are, you know, very few protections in place for folks in that situation. You know, we have intakes from people who, you know, live in accessible units or in places that have been modified to fit their disability related needs. or are otherwise, necessary for their safety. So for example, I represented a woman who had a condition with her heart that required her to have access to electricity. So simple things like that, just having access to electricity for people with disabilities is extremely important. And when you are, when you're facing homelessness, you risk losing that. And that's, extremely stressful for folks. In that case, my client had already been evicted and was living in her vehicle when she contacted us. So she did not have regular access to electricity. It was significantly impacting her health. As a result of her eviction, she had also lost her voucher. She had a RAP voucher, which is the state equivalent to Section 8. So she had lost that voucher because she had been evicted. And we were able to get that back for her. So that's, one of these areas where we can see a real intersection between, fair housing issues, disability rights, access to safe and affordable housing, access to vouchers, and also to, the summary process. So that's just one example. I saw a question, and I would be happy to address questions as we go. So the question in there is, does the Fair Housing Act cover someone being denied housing due to them being head of the household and a student? Well, in Connecticut, age is a protected class. So being a student on its own is not a protected class. So that means that, if, just by being a student, you're not necessarily protected. However, there have been some very important cases in Connecticut that showed that age and status as a student, there's a disparate impact. If you are discriminating against students, it has a disparate impact on people based on age. So, so there are some protections, available, but I would need, to know a lot more about the situation. And age is not a federally protected class. It is only, it's not only in Connecticut, but it's a state protected class. And I don't know which other states, have it. So, but if you're in Connecticut and you have been told, oh, we don't rent to students, that is definitely something that should be reported, by contacting our agency or by contacting the State Commission on Human Rights and Opportunities. Because having a policy of refusing to rent to students may violate the state fair housing laws. So just to get into a couple of other issues where we have seen some, significant activity. And this I'm sure is a national issue, but in Connecticut, we have the emergency rental assistance funds. And there have been a few iterations of this program now. It started, in the fall of 2020 with a sort of limited program, and then it expanded and we had some more resources, and now it's sort of contracted again, but we still do have a program. So, this is, of course, a symptom of the pandemic and a, direct outgrowth of it. And what it means for us is that we have all of a sudden, all new lawful sources of income that people are being discriminated against based on. So we have had to, that's been a major area of expansion for us, is looking at, these rental assistance programs and figuring out in what context are people protected. And so, that has definitely accounted for some of our increased intakes. And, while we also have a lot of our traditional source of income intakes, which are, Section 8 particularly, we have seen a large increase in people contacting us because their landlord refused to accept the emergency rental assistance funds that were available. And this is something that was covered pretty extensively in the press because, landlords were complaining about, oh, tenants weren't paying, but then at the same time, they were refusing to actually accept rent from people when it came in the form of rental assistance. So we filed several actions, both in state court as well as at the Commission on Human Rights and Opportunities, which is our state agency that adjudicates fair housing violations. So we are still litigating those, and some of them have settled and some of them are in the middle of litigation. So there has not been a written decision from a judge on these cases. So it's if you're familiar with litigation, it's a slow process. It can take many years before we actually have a written decision on them. But we have had a lot of luck helping tenants advocate with their landlords to get them to accept these funds in order to save their housing, by using the fact that it is a lawful source of income. And that's very satisfying because, when we don't have to resort to litigation and we can just explain to landlords, hey, we have these protections in Connecticut, you have these funds available. Wouldn't it be better to take money than get sued? Like, which is better? So, we have had a lot of luck with that. And that has definitely been a big part of the work that we've done over the last couple of years. I also want to talk about, I've been talking about Section 8 and lawful source of income. And one of the trends that we're seeing there, and this also has been reported recently in the media, but many people with vouchers are seeing that the time between when they get their voucher or when they need to move and when they can actually move has increased significantly. And the challenge there, if you're familiar with Section 8, they have a deadline. People with vouchers are given a deadline by which they have to use their voucher, or it could expire. Now, some of our work has revolved around getting housing authorities and voucher administrators to extend that time to give people additional time. But the reason we're seeing so much of this is that rents are much higher. They are harder to find. And so people with vouchers are, not only having everybody's having difficulty finding housing, right? But if you have a voucher, you're in a unique position where, you're very limited in terms of the amount of rent that you can pay. It's a set number. You don't have a lot of flexibility for the most part. And you have a deadline by which you need to use it. And so when everybody may be facing a shortage of housing opportunities, but if you as a voucher holder miss out, then not only do you not have housing, you also have lost this very important and significant subsidy. So, when people are being told, no, we don't take Section 8, that is just an additional barrier. But even when people aren't being told that, they may not be able to use their voucher on time. So that's been another area of work for us. We have had luck in getting voucher times extended, especially for people with disabilities. But you should be aware that, even without a reasonable accommodation, tenants are entitled to extensions on their voucher and should seek that out. And if they've been discriminated against in the process, so, if you have gone to a landlord and been told, no, we don't take Section 8, and now your voucher is set to expire, we definitely make the argument that, because of the discrimination, the voucher should be extended. So that's something that we've had to deal with quite a bit, and try to assist people in getting that done. And there are a lot of reasons that it takes longer to lease up with a voucher. Some of them are inherent in the program, but like I said, it is a direct result of the housing market and the lack of availability and the lack of affordability that we're seeing. So let's see, I also want to touch on some of the other issues that come in that are more sort of straight landlord tenant, and have maybe less of an overlap with fair housing. And Maria is going to get into some of the ways that we've been working on those issues. So a big one is rent increases. And rent increases are, they're pretty much unlimited, and so a landlord, has a lot of flexibility in terms of setting the rent once a lease has ended, right? And what we saw with the pandemic is that many leases expired and were not renewed. And so it made it very easy for landlords to start increasing rents. And so when people contact us with rent increases, our tools are fairly limited. And that is one of the reasons that we put a lot of resources this year into advocating for what's called, cap the rent. And that would be a legislative solution to this issue. So, we advocated at the legislature on, putting limits on how much landlords can increase rent. There was a hearing on this. It went basically all night because there were so many people who wanted to testify about their experience, predominantly tenants. And, it was in many ways a very successful campaign, though at this point the legislation has not passed. That is unfortunate, but I still think it was a success in that, it has raised the profile of this issue in a way that hasn't necessarily been addressed in the past. So capping the rent is an important solution here because right now the law doesn't have a lot of tools. However, there is one tool that is available to tenants in Connecticut that has also expanded, and those are called fair rent commissions. I don't know if these are in other states, but in Connecticut, municipalities operate what is called a fair rent commission. And legislation from 2022 required an expansion in fair rent commissions. Previously, they were essentially optional for municipalities. And now by July 1st of this year, any municipality with 25,000 or more people is required to have a fair rent commission. And so this was a significant success and gives us a tool when people contact us with a rent increase to say, okay, well, your municipality will have this in place, contact the municipality. It gives people an opportunity to challenge a rent increase. The only other protections that are available are for people who are 62 years and older or who have a disability in the household and have 5 or more units at the property. There are limits in the statute on rent increases for folks in that situation, and they can enforce those through the courts. We get a lot of calls from people in that situation, and unfortunately, the legal process for doing it is not super straightforward. So the tool is there, and we have helped people advocate on that issue, but it's not super easy to enforce. So the protection is there, but the fair rent commissions, when those are fully expanded, will be applicable to everyone, regardless of disability, regardless of how many units there are in the building. So that's extremely helpful. Another issue that we see coming up a lot are what we call no cause evictions. And so, a no cause eviction, and, people are often very surprised that this is a thing. They'll say to me, well, I didn't do anything wrong. Like, I've paid my rent on time. I'm a good tenant, et cetera. And I have to say, like, I get it. You may be the best tenant, but you can still be evicted because your lease has ended. And so that's what a no cause eviction is. I think most states have some version of this. But in Connecticut, it's a pretty aggressive version. You don't have to be given very much lead time before the case can start. And you may have to just leave because your landlord didn't want to renew your lease. Now, obviously, there are situations where, there's nothing that can be done. However, many times, you're going to see an overlap between these no cause evictions and discrimination. So although the tenant may have done nothing wrong, maybe the landlord doesn't want to rent to folks with vouchers anymore. Or maybe there's race discrimination that hasn't necessarily been voiced, but some tenants are being evicted and others are not. So those are things that we see and that we screen for when we have lapse of time cases. There are also protections. The only folks who are protected from lapse of time, these no cause evictions, are people who have disabilities or people who are 62 and older. So again, there is a sort of fair housing overlap in terms of the population that we serve. So when we see people who are protected being evicted under, for no cause, we are able to intervene because the statute says, no, you can't evict this person for no cause. So that has been another area of expansion for us. I do see a question about fair rent commissions. So the question is, how do the fair rent commissions work in practice? If you came to them with an unfair rent increase, what can they do? So that's a great question. And I will say first that, different municipalities operate in different ways. However, what I can tell you that is, should be universal, is that, the statute basically empowers these commissions to consider a variety of factors in determining whether a rent increase is in fact fair. And there's a statute that lists a non-exhaustive, section of things that can be considered. So things like, obviously prevailing rents in the area, the conditions of the unit, and the percentage of the increase, all kinds of things can be looked at. And what the commission is empowered to do is actually to say to the landlord, no, you cannot raise the rent by this amount. You can raise it by a smaller amount or not at all, potentially, depending on the situation. And they are also empowered to tell landlords that they cannot bring an eviction against this tenant for refusal to pay the increased rent, and doing so may violate the retaliation protections. And the commissions are actually empowered to say, no, you can't do that. And so, it's a injunctive relief for tenants to actually, proactively prevent a landlord from evicting them because they wouldn't agree to the rental increase. In practice, I don't have a lot of statistics and information on how often the commissions are actually saying to landlords, no, you can't reduce, you can't increase the rent by that much. I think as these commissions increase across the state, we're going to get a lot more information. So hopefully next year we'll have more information on how these are actually working in practice and what types of outcomes tenants are seeing. But, personally, I have seen the commission say, you're asking for $700 a month in increase. No, but you can get $200 a month, just as an example. And those are the types of increases we see regularly. We're not talking $50, $100 a month increases. We are seeing, very large increases, sometimes 40, 50% or more. How are commissions chosen? It is a municipal appointment. So the town legislative body and or mayor, depending on how local government is structured. We have 169 towns in Connecticut. We do not really have a county government structure. So it is, they're each their own little fiefdom. And so all these municipalities, they may have slightly different processes, but it is by the town government. They select commissioners. I don't know if there's a set number on each commission. I think typically what we're seeing is 5 to 7, but that I'm not sure if that's statutory. But yeah, they're chosen by the municipality, and it is a unpaid, appointment. So they are not employees of the municipality, but it is, like other commissions, it's just an appointment. All right. So the last thing that I wanted to talk about are conditions. And as I mentioned, that is one of the factors that these fair rent commissions can look at. But it is also, a major factor in people contacting us post-pandemic, because, to be fair, I don't know how significant conditions issues were before, but people weren't really contacting us about it very often. That number has gone up significantly. I regularly am hearing concerns about conditions, landlords not upkeeping properties, just not dealing with infestations of rodents and other pests. So this is a really common issue that we're seeing, and it's being coupled with, for example, 50% rent increases. And so when you see that, that, feels like something you want to do something about. But the Fair Housing Act is not particularly robust in helping us deal with that. So we've had to look at some other ways of helping tenants on conditions issues. And so with that, I'm going to turn it over to my colleague, Maria, and she's going to talk about some of the ways that we have been working on those issues in particular, as well as many of the other tenant issues I've talked about.
Thanks,
Maria?
Pam. Yep. Hey, everybody. I'm going to talk a little bit about a different way that we've started working in our office to try and address some of these systemic issues that we're seeing. As Pam said, what we're hearing about and what's going on has changed a lot over time. And our office has worked hard to try and respond to what we're seeing is happening to people out there. And as Pam said, even before the pandemic, the US was already experiencing a housing crisis. A full-time worker earning minimum wage could not afford an average 2-bedroom apartment in any state in the country. And nearly 50% of all renters were spending at least a third of their income on rent, while 25% were paying over a half of their paychecks to their landlords. And those stats are consistent with what's been happening in Connecticut. And since the pandemic, things have gotten a lot worse. Rents are rising at alarming rates, which everybody knows about. We've seen a massive surge of evictions and displacement from housing. Corporate, often out-of-state landlords are buying up properties and pushing out long-term tenants by not renewing leases unless the tenants agree to large rent increases, refusing to repair conditions, or just evicting tenants who don't have leases. And once units are empty, landlords often are fixing them up, jacking up the rent to unaffordable levels. And we've seen cases where, like Pam said, rent has gone up by 50% or even more. And like Pam said, we've always had a fairly open intake system. We don't have any income requirements as well, but we've really tried to get a better sense of what's happening out in the community and try to have a more dynamic response to what's going on. And, it's become clear that systemic failures are causing really catastrophic impacts for low-income families of color. Matthew Desmond, who wrote Evicted and Poverty by America, helped a lot of us see that if the criminal justice system has had a clear disparate impact on Black and brown men, the eviction system is having a similar disparate impact on Black and brown women. Being evicted ruins people's lives, and it can lock them out of housing for many years. And yeah, we've had a lot of calls from tenants who are living in just appalling conditions, and sometimes in units where the landlord is wanting to raise their rent to unreasonable levels. And so often we've had to tell them, I'm sorry, this is not a fair housing issue. Like Pam says, we've made an effort to try and find the fair housing angle for many cases, but many times we've had to try and refer them out, and there's just not a lot of help out there for folks. So when we turn them away, it's really, really upsetting for people. And they say, I thought you helped with fair housing. I thought, and this is not fair. And, it's painful to turn people away because what is happening is not fair. So for those of us taking a lot of calls, it's very heartbreaking to hear the cruelties that people are experiencing and to have to tell them over and over, I'm sorry, we can't help if you have poor conditions, rent increases, or evictions when they're not related to discrimination. So we decided to broaden our definition of fair housing and to try and include issues beyond the strict legal definition of discrimination, because systemic issues are clearly having a disparate impact on entire groups and affecting their ability to thrive and to even survive. So those of us who were interested began working with tenant unions a few years ago to try and build grassroots power and to work on enacting legislation needed to protect tenants. In 2021, in coalition with other groups, we were able to pass right to counsel in eviction cases in Connecticut, which means that tenants facing eviction are guaranteed a lawyer. That's being rolled out, and it's currently only in certain areas, but every year more and more people become eligible to have a free attorney for their eviction defense. And in 2022, legislation was passed that Pam referred to that required all cities or towns with over 25,000 inhabitants to create these fair rent commissions, which are voluntary bodies where people can file complaints to try and address unfair rent increases. And then we also worked a lot on rent control legislation during this last legislative session, working alongside a large statewide coalition of labor unions, churches, tenant organizations, immigrant right organizations, and others. And in spite of a poll that showed that 72% of Connecticut residents supported rent control and an amazing grassroots campaign that brought hundreds of everyday people out to testify, the legislation failed. Even though the votes were there to get it out of committee, the Democratic leadership killed it. So building this movement, brought a lot of people into the process and helped get the word out about what tenants are dealing with and contributed to the creation of even more tenant unions. Currently, there's about 10 active tenant unions around the state. And the campaign also showed that those suffering under unfair rent increases showed those that are suffering with this, that most politicians really would rather protect the power of landlords than find a way to address this crisis that people are going through. And then in our office, we started providing representation to groups of tenants in situations where people were facing displacement because of these high rent increases or living in terrible conditions. I'll give you one example of a group we worked with, which was a group of tenants in Hartford facing displacement. Many of these tenants who were mostly undocumented lived in 2 buildings in Hartford for many years. A new landlord had bought the property last year in June and informed the tenants that rents were going to go up by 1/3. We did some research on this landlord and learned that his MO, because he had like an Instagram page with all his great victories of buying distressed properties, raising the rents to unreasonable levels, not making repairs as a strategy to push people out, and then rehabbing and flipping the property. So the tenants responded by forming a tenant union, working as a group with the help of organizers and advocates from our office and from Make the Road Connecticut. The tenants wrote numerous letters to the landlord telling him that they would agree to rent increases if he would fix up the conditions in the building. The conditions were appalling. There's water pouring through ceilings, just really, really bad. And the landlord responded to their letters by sending notices to quit to a number of the tenants. So because of our involvement, we were able to get these tenants, initially we got them pro bono counsel and were able to get their eviction cases dismissed because the action taken against them was clearly retaliatory. And luckily, Connecticut just happens to have a statute dating back to the 70s that makes it illegal to retaliate against tenants who have formed a tenant union. So the tenants continued to push the landlord to fix conditions. They got code enforcement in there, inspections were done, and the landlord still refused to make the repairs. So they filed, which you can do in Connecticut, you can file a case in housing court to pay their rent into the court. They also filed complaints with the Fair Rent Commission in Hartford, and while those processes were playing out, which took over 5 months, their rent did not go up and they were protected from retaliation. So it was a way to sort of get the tenants some relief in the meantime and protect them during the process. And then an attorney from our office did represent them in their payment into court cases, and we were able to get the court to consolidate their cases into one case. And this pushed the landlord to make repairs. And so after paying their rent into court for 5 months, they were able to get half of that money back, but did have to agree to a rent increase. But we were able to get the landlord to agree to not evict them nor raise their rent again for a year without giving them a lease. so that they were able to leave if that's what they wanted to do. So these kinds of strategies will obviously differ state by state, depending on local housing law. But one of the things it taught us was that systems that are supposed to support tenants, like code enforcement and fair rent commissions, don't often work that well if people are dealing with them on their own. There's a lot of lawlessness and many failures that make tenants vulnerable to displacement and homelessness. And, giving people advice to go to these places often doesn't work if they're not in a group or don't have representation or don't have some sort of power behind them, because these systems and institutions just don't do their work the right way often. In Connecticut, it can be impossible to get reports showing that an inspection's been done, something a tenant needs if they're going to prove that an action against them is retaliation. So this lawlessness and this culture of impunity that low-income tenants are facing really needs to be talked about and responded to. I would say it's very encouraging to see that all over the country, more and more people are forming tenant unions to fight the power and access that landlords and property owners have to try and equal the playing field. And a lot of these groups reject the model where experts are the ones determining what justice means, and where lawyers are not the only ones driving strategy or deciding what winning means. And obviously, doing this work in the housing context is really complex, because when the process involves the courts, you often do need a lawyer to have any chance of winning. And when lawyers are involved, it's hard for tenants to push what they want and need as a group, because it's just, the law is very complicated, and what people can get under the law is quite limited at times. So there are contradictions that need to be kept in mind. But movement lawyering, which is what we've been trying to do and support, is a way to support organizing that can recognize how the typical lawyer-client relationship often involves a lopsided power dynamic, where tenants can feel that their concerns are being ignored by us because of the limitations of the process. Movement lawyering envisions that our work as advocates should support organizing work rather than driving the process. And I think that we as organizations need to invest in ways that allow us to shift our practice that helps build tenant power, because doing things in the same old way is not, frankly, moving things forward. Things are getting worse and worse for tenants, and I think we need to start thinking about new ways to do our work. And I think we need to recognize some hard truths, that the safety net for low-income people is pretty much gone. And a lot of nonprofits do very little to challenge a system that treats low-income people and treats our clients as disposable. If we really believe that people shouldn't have to put up with their rents going up 30% per year, and that people do deserve a safe, sanitary place to live, I think we need to shift the way we do our work. And I don't want to say, I'm not saying that we shouldn't do individual cases, nor that work is not good, important, valuable work. Obviously, casework makes a huge difference to a client who needs a therapeutic animal or who's been discriminated because they're in a protected class. And doing individual casework does send a message to landlords. But let's be honest, doing individual cases often does very little to change the underlying conditions that gave rise to the complaint to begin with. And when we have to prove discrimination, which is never easy, it means we can't accept a lot of cases, and a lot of people are turned away for very unfair, unjust situations. So my plea is that we need to look for other ways to help people who are systematically locked out of housing because they're in a protected class, because they're poor, because they have a criminal record or a disability or whatever. So my plea is, let's expand what the word fair housing means. Thanks. I don't know, do we want to take some questions, or do we want to move on to our next our next presenter, what do people think?
Hey, Maria, I do see one question that I think we should pause to answer now, and it is from Gwen. How are they being held accountable to do their jobs? Is there a way to hold systems accountable if they are not following the law?
That's a great question. Yeah, I mean, it's really, really tough because we've done a lot of work, you know, organizing tenants in Connecticut, in Hartford, for example, and, you know, gone to the city council to try and address, and maybe Pam has an answer to this too, but to try and address sort of the way inspections are not getting done, landlords are not getting fined for poor conditions ever, you know, and it can be hard to sort of, unless you can sue the city, which often is impossible, it can be hard to hold them accountable. But if you show up over and over with a large group of people to the city council and, you know, try and demand action and get press and have a campaign, that can be one way to do that. I mean, you know, someone asked before about fair rent commissions and how they're working. And a lot of them just aren't doing their job. A lot of them don't know the law. And, you know, I think that by trying to utilize these systems that are out there, it can be super hard to change when they are not acting, you know, in accordance with the law. It can be hard to change that unless you have a movement of folks pushing them to change, where, you know, you're calling on legislators, you're going to the press, you're pushing in a different way to make them follow the law. It can be really hard. I mean, we see it in housing authorities all the time. There's so much lawlessness in the way they treat people. They treat, you know, they treat people who have subsidies through housing authorities, you know, as criminals pretty much. And it can be really, really hard to deal with that with individual casework. Did you want to say something, Pam?
Yeah, I mean, I will just say, first of all, I agree absolutely with Maria that, you know, from a global perspective, the only real way to address that issue is through organizing and through action, you know, grassroots action. You know, and I will share that occasionally I have, you know, gotten calls from people who are in positions of power in municipalities and legislatures who are like, oh, can you help this tenant? What, this seems really unfair. And sometimes I have to nicely say, well, actually, you have the power to fix this situation. Well, what can they do? Well, if you follow the law that already exists, then you could actually help them. So we've, you know, this comes up around conditions, and when a municipal official contacts us and like, oh, this landlord isn't fixing, you know, whatever. Well, the municipality is empowered by the legislature to take action in those situations. So it is sometimes a question of, you know, entities that actually have the power not using it or not understanding how it works. You know, and so that can sometimes be, you know, an issue of education. On the other hand, you know, I have had to say to clients and callers who contact us, like, the system is only, you know, the legal system only works when it's actually being enforced. So yes, what you're saying, for example, is it is against the law, but are you going to get a remedy for that? Probably not. And so, you know, I think that that is a reality that is unfortunate sometimes, you know, even when there is stuff on the books, how easy is it to enforce is a different question. And, you know, that's why one of the things I touched on was, you know, cap the rent. Like, we have some protections in place for rent increases, but they're difficult to enforce. And so, you know, having something through the legislature is probably the only way to actually change that. And even if that passes, even when that passes, how easy will it be to enforce it? I don't know, you know. And so there's a lot of layers to it. I want to see, you know, if we have any other questions right now.
I see a lot of comments in the chat box right now. but no further questions. But I think this actually is the perfect segue into your second piece, Pam, because there are some times where we're unable to really take the complaints the way that we would like to, or enforce the Fair Housing Act that the way that we would like. But there are some key times where we are able to. So I kind of want to talk about enforcement in action now, and kind of how have we been able to enforce the Fair Housing Act in some of these cases and get a positive outcome for people who have been discriminated against.
Sure. Yeah. Thanks, Rashida. So, you know, we are litigating fair housing cases every day. And, a lot of times they result in settlement. Occasionally they result in, trials and decisions. And those tend to, be significant. And so one of the cases that has recently recently it was 2021, but it feels very recent, went to trial and we got a decision, is a case involving an organization called Gilead that operates group homes and facilities for people with mental health conditions. And they wanted to build or operate such a facility in the town of Cromwell. And they were denied that opportunity. And so, this is a disability case. This was a disability discrimination case. But, similarly, you can think about affordable housing in the same way, right? And the Fair Housing Act can be a tool to ensure that municipalities that have a lot of power, especially in Connecticut, where again, we have these 169 municipalities that are all enforcing their own zoning laws, enforcing their own, building codes, et cetera, to ensure that they are, not promoting segregation, that they are affirmatively furthering fair housing, which they are required to do, and that they're not, discriminating against people based on disability. So the Gilead case, again, it is a disability case, but it is, an example, more broadly speaking, of how the fair housing laws can be used to ensure that municipalities are not discriminating and not promoting segregation, whether it's based on race or disability or some other protected class. So we had great success, in this case. It resulted in a very generous verdict that, currently the case is still being litigated. But we were able to, and the slides that are up now kind of show the basis, some of the basis that we had in this case. Cromwell residents praise council for, discriminating is the, missing part of that headline. So these were some of the press that occurred, around the time that the issue was of the prior to the litigation, essentially. And so, if we go to the next slide, we can see that this was the result. It took a lot of years, right? So six or so years, but a federal jury awarded $5 million in punitive damages to our clients because of the, way that this group home was blocked. And again, this is one example of how the Fair Housing Act can be used in a way that is very powerful to ensure that municipalities do not promote segregation. So if we want to go to the next slide, there was at the same time actually another case that we settled that the Justice Department was involved in as well, against another municipality, very similar facts. And so, again, these are just some examples of some, important cases, but the Fair Housing Act, as it can be used in creative ways. So a lot of my cases are individuals suing their landlords, right? And that is a powerful tool, and I have used it many times to get settlements and outcomes for clients, right? But you know, that's an individual case, right? So when we can bring cases that have a more systemic impact, you know, we try to do that. And these are two examples of those types of cases. In terms of, you know, what this could look like for fair housing organizations nationally, you know, it is about, you know, local zoning rules, local enforcement of, you know, mob rule, so to speak. So when you have, you know, townspeople coming and protesting something, you know, sometimes referred to as NIMBYism, right? And you have, you know, this big uproar in the town. If the municipality decides to embrace that and make that their policy based on these discriminatory viewpoints, then they can face liability under the Fair Housing Act. So it's definitely something that you know, fair housing organizations should be looking at for situations where, you know, I mean, obviously, you know, democracy, you know, we want the people to have input, but sometimes the people's input is racist. Sometimes it is ableist, you know, and when that is their basis for opposing something, and the town is like, yeah, you're right. We you know, we aren't going to let those people with mental health conditions live near a school. Like, yeah, that seems like a legitimate concern. When they embrace that, when they endorse those viewpoints, they can be liable. So, you know, I know that some of the folks on here are municipal officials themselves or otherwise connected to local government. It's a good thing to be aware of from that perspective as well. You know, and for those who are fair housing advocates, like, you know, keep an eye out for those types of scenarios where, you know, the litigation can have a real impact beyond just your individual client, right? So that is pretty much all I wanted to say about those cases. I also, you know, wanted to mention, I previously talked about some expansion in our source of income cases to situations where we have the ERAP funds involved. So that's been another way that we've been able to use litigation. But finally, you know, I also want to talk about some of our reasonable accommodation cases, because this is another powerful tool that we have been able to use to help tenants with some of the condition situations that we see. So, you know, we are another way that the Fair Housing Act can interact with, you know, these landlord tenant concerns is through the reasonable accommodation process. So now, a reasonable accommodation is defined, right, as a change in a policy or practice by a landlord. And if the landlord's policy or practice is to not maintain a property, you shouldn't need a reasonable accommodation to get them to fix it, right? But sometimes you do, because that's all you have. That's the only tool you have. So we have been able to actually make reasonable accommodation requests for tenants to say, you know, you need to fix this. I have a disability, and this condition, although it's bad for any tenant, is even worse for me because of my disability. You need to fix it. So that is another way to use the Fair Housing Act to sort of creatively assist people in situations where they're facing, you know, problems with their landlord that maybe aren't explicitly discriminatory on, but where they have rights that they can enforce. Another scenario is requesting a transfer. So when people live in subsidized housing, and, you know, they certainly, you know, leaving isn't an option, because if you leave subsidized housing, you no longer have your subsidy, right? It's attached to your unit. When folks are in those situations and they're facing conditions problems, the only real option is to transfer to another unit operated by the same landlord. So that is another way that reasonable accommodations can come into play. And we've seen this come up a lot in, you know, situations where there are pest infestations. And in fact, you know, Maria had a case with a client who had such a horrific pest infestation. The landlord had done nothing. And, you know, we had been requesting a transfer. The landlord came to the unit, and in fact, a cockroach fell on her head. So to me, that was, you know, a moment of sort of justice. I mean, ultimately, the tenant needed to be moved, but, for a landlord to actually have that experience and to understand what was happening, I think it's too bad it takes that. But when that happens, I think, it is justified, and we like to see situations where landlords have to experience even a small bit of what they're putting their tenants through in terms of conditions. But yeah, so that is another tool that we have available. Okay, and there's a question about is the move supposed to be at the expense of the landlord? The easy answer to that is yes, because there is a law called Section 504, right? This is a disability related law. So if the transfer is due to disability, and if the tenant is living in federally subsidized property, this does not include Section 8 vouchers, and it does not include low income housing tax credit properties. But a lot of the in-place vouchers and other subsidies that are through HUD are qualified under 504. And 504 specifies that the federally subsidized entity does need to pay for the reasonable costs of accommodations. And that can include paying to move someone. And we certainly advocate that if a person needs to move due to disability, that the landlord should be paying for it. That will not be the case in private housing. That will not be the case with a voucher, but if it is federally subsidized at the property level, then yes, we would be advocating for that. It's not always something that they are ready to agree to. So that can be an issue in litigation, or it can be an issue for negotiation and compromise to get somebody what they need. So there's different ways of dealing with it, but yes, a federally subsidized landlord should be paying. And they're not volunteering usually though for that. Okay, so I see a comment in here. I know of a senior in senior housing in Massachusetts who's requesting an accommodation for a walk-in bathtub, and the local housing authority is refusing the accommodation as unreasonable because the housing authority would need to pay to install it and then pay to remove it after that tenant leaves. Right, so that is a reasonable modification. And in fact, that's so the factors that a housing authority, can look at when they determine if a cost is reasonable or not, include things like their operating budget. They may have to put off other repairs if there's a reasonable modification that costs money. It's not accurate to say that they would need to remove it, because many tenants could benefit from that, and it doesn't make it unusable. So there are situations where a modification would need to be changed after the tenant moves out. To me, a walk-in or roll-in shower is not that, because anyone can use those showers. You don't have to use a wheelchair to benefit from it. And no, in my opinion, it's not a valid factor for refusing the modification unless the expense was enormous and the housing authority is facing bankruptcy or something. Like it would have to be pretty extreme. And most of the time when these housing authorities say, oh no, it's too expensive, that's not true. And that is definitely a basis for a HUD complaint. And the burden is on them to show that this is going to have a real financial impact on them beyond. And again, they might even have to delay capital improvements if that means paying for a reasonable modification. So I do think that that sort of scenario is one, it's in Massachusetts, so it's not us, but I think that if a person came to us with that scenario, I would certainly be advocating and potentially filing a complaint if it was denied. So, and let's see, I'm just reading. I don't think there are any other questions in here. There are lots of comments.
There's a question, Pam, about an elevator situation with a broken elevator.
Oh, okay. Okay. So elevators are tricky. They are a more complicated question because You know, there are oftentimes difficult to repair, even if you're actively trying as a landlord to get it fixed. You may not have the right parts, you may not have the expert, you know, repair person available. So there are situations, unfortunately, where if an elevator breaks and the cost to fix it or replace it is too high, it might not be reasonable for it to be fixed. Now, this is, again, this would be in a building in which, you know, pre-1991, where, you know, the design and construction rules don't apply. But in those cases, you know, transfers have to be made of tenants to accessible units. So if an elevator isn't going to be repaired, then tenants have to be transferred. But and the other thing is, a landlord has to make the effort. They can't just be like, oh no, it's too expensive, I'm not going to do it. They have to be making an effort, and that's usually enough. When we've had these cases come in, you know, we send a letter and say, you know, landlord, like, you have to at least attempt to fix this elevator. Like, and if you're not going to fix it, you need to actually have proof that doing so would be, you know, cost prohibitive in some way. So usually when they're pressed on it, it ends up getting fixed. But if it doesn't, and if a person is stuck in a building who can't use stairs, then transferring them at the expense of the landlord is certainly the next viable option.
There's another question, Pam, about a person in senior housing in Mass who's requesting an accommodation for a walk-in bathtub, and the local housing authority is refusing it as an unreasonable modification, I guess, saying that because they need to pay to install it, then they'd need to pay to remove it after the tenant leaves.
Yes. Okay. So I read that question previously, but just to answer it again, I mean, first of all, they don't have to remove it when the tenant leaves. They could choose to remove it, but again, the expense of that would have to be so high. You know, it's unlikely that, given their full financial picture, they could justify not paying for it. They love to say, oh, too expensive, but that's almost never the case with modifications. I mean, you know, obviously there are modifications that could end up being so expensive that it's cost prohibitive for a housing authority, but that is pretty unusual because the modifications, such as a walk-in shower, are not that expensive when you take into account the entire budget and, you know, things, again, like their general operating expenses and things of that nature. So it's unlikely, you know, that most modifications are going to be denied. Well, it's likely they'll be denied for that reason, but it's unlikely that they are justified in that denial. So that may take litigation to get them to do it, or it may just take some advocacy by a fair housing organization. So, you know, there is a comment on here. I wish you experts would do a monthly legal hotline for tenants and people who attended this conference. So I appreciate that comment, and I you know, I see there's a response from with a Berkshire County number. I also want to mention that, you know, as I said previously, we take calls. Although I can't address legal issues in other states, if you are in Connecticut, you're welcome to call us with any questions at any time. We also have a contact form on our website, and we have, I think there's a slide actually with some other organizations that may be helpful in Connecticut. So I can't speak to other places. And I do see one other question on here that I'll just quickly address. How about healing gardens as reasonable accommodations for neurodivergent folks or people with PTSD? Yes, absolutely. I have not had that reasonable accommodation request come to me, but I would definitely, you know, if a healthcare provider says, because of your disability, you would benefit from this, I would definitely advocate for that. It would be at the expense of the tenant. It's not the kind of modification that we could ask a landlord to necessarily pay for, even in a 504 situation. I don't think it's a little, you know, I think that is on the tenant in those cases. But, you know, if what you need is permission to do it, absolutely. I think that, you know, that's a great idea. And something that I would certainly, you know, advocate for if my client needed, you know, the ability to have a garden. and the standard, I know this is not a presentation on reasonable accommodations, but I am sensing there's a lot of questions on it. The general standard is, is it reasonable, right? Is it an undue burden on the landlord, or is it a fundamental alteration in the landlord? So, in what they offer. So most accommodations that we can think of are not that, but there are some that would be. For example, replacing an entire elevator, that might end up being an undue burden. So, but it's a very individualized assessment, and something that, again, if you have questions in Connecticut on reasonable accommodations, if you need a reasonable accommodation, or if you have clients or constituents who need reasonable accommodations in Connecticut, absolutely reach out to us, go to our website. And again, here are some resources for you to look at, including information on Cap the Rent, and some other reporting that has been done on some of the issues that we've talked about today.
I'm just going to throw out quickly too, because I don't think it was mentioned, but it's just, for people who have disabilities who are trying to get accommodations or modifications. I mean, the way to start is with a letter from the doctor or a medical person who's treating you to talk about why, you need the change. Because there's been a lot of questions about, the issue of reasonable accommodations, and everything needs to start with proof that having the accommodation, will be good for you. And so starting with doctor's proof that links your disability with the need for the change is the place to start. But I'm assuming that fair housing orgs, all over the country, hopefully do these cases, and that you should call them for some guidance. Because there's a lot that can be done, like Pam said, to make adjustments for folks with disabilities.
Yeah, and that is absolutely true, Maria. The only exception is that, if the disability and the need for the accommodation is obvious. For example, a person who uses a wheelchair and needs a roll-in shower, that's an obvious one where you don't need a doctor's note. But the vast majority, you do need a letter from a healthcare provider of some sort. It doesn't need to be an MD. And another question has popped up in the chat. What about when they deny those accommodations? Again, an accommodation can only be legally denied if it is an undue burden or a fundamental alteration from the landlord. I rarely see those situations, and that doesn't mean the landlord won't try to deny it. And that is where the fair housing organizations come into play. In Connecticut, we file cases all the time because landlords failed to grant reasonable accommodations. Though I will say the vast majority resolve before we need to get to litigation. We can resolve them through making demands, explaining to landlords what the law is, and then most of the time they follow it. If they don't, they end up paying for it. Some of my biggest cases have been reasonable accommodation cases. And, I had one, this was a while ago, but, they didn't want to give my client a parking sticker for her aide. She had an aide who came to take her to many medical appointments related to her disability. They didn't want to give her a parking sticker, even though their parking lot was enormous and not full ever. They didn't want to give her this, $25 parking sticker. And so they ended up instead paying $25,000 because we had to sue them and give her the sticker, So, if landlords do deny them when they're supposed to grant them, then they end up sometimes being liable, and it's the results can be significant.
I mean, and I'll just quickly say, it's just good practice for everybody in housing situations, but especially in fair housing discrimination cases, to do stuff in writing, like write letters, date them, keep a copy, ask for things in writing, ask for the reply in writing, and all of that helps you prove your case down the road if, something can be done.
Awesome. So I'm looking into the chat box. I'm not seeing any other questions. I want to take this time to thank the organizers of this conference for, having us present this year. We are so appreciative for, being offered a time slot and an opportunity to share the work that we've been doing with our nationwide comrades in fair housing. So thank you all for attending today. This is also being recorded, so at some point you will be able to access this recording again. And here's our contact page. Pam did mention, we're unable to hear complaints or, give legal advice for things outside of the state. But, if you are in Connecticut and you would like, to learn a little bit more about the work that we do, to connect with our organization, or, to report discrimination, here is our contact page where you could reach us. So thank you to our panelists. Thank you, Pam. Thank you, Maria, for sharing your expertise today. And I am just so grateful for this opportunity. Thank you, guys.
Thank you. Take care.
Thanks, everyone. Good luck out there.
And again, just on behalf of the conference, let me just thank you very much back for being here and for providing this wonderful workshop. And just remind everybody that our keynote speaker today will be Demetria McCain. And that will be at 12 o'clock today. And there's still another round of workshops this afternoon. And again, to all of you, thank you for attending, and specifically, thank you to all of you who presented today. This is a great workshop. Have a good day, everyone.
Bye, everyone.